board of directors of IFP, and I hold the position of treasurer on the board. So we're in our home stretch now, the summit, and we'd just like to remind you of a few opportunities that we have today so that you don't miss out. You can join today for $159. For IFP members, you can subscribe to Coming Up Next, IFP Own Advisor and Succession Planning Program for just $59. And finally, you can register for the Spring Summit on April 24th and 25th of 2019 for a special rate of $109 for IFP members and $209 for non-members. This special pricing is valid for today only. So be sure to lock in your registration at this rate. So you can just stop by the IFP booth and make sure that you take advantage of all these specials. So our next presenters, Gerry, Gill, and Brett Stephenson. They're with the law firm of Dolden, Wallace, and Fullick, LLP. Gerry Gill has spent his entire career in the insurance defense field. Prior to joining Dolden, Wallace, and Fullick, LLP Toronto's office in 2013, he held a senior claims position with a Canadian commercial and specialty lines insurer, where he was responsible for all management, executive, and professional lines claims, including directors and officers, liability, and professional negligence matters. In addition, Gerry developed and implemented claims handling protocols for all professional line clients to increase claims handling efficiency, reduce claims expenses, and eliminate and minimize claims activities. Joining Gerry is Brett Stephenson, an insurance defense litigator, acting on behalf of numerous prominent domestic and international insurers. Brett has a diverse practice defending claims involving professional liability, complex bodily injury, products liability, occupiers liability, liquor liability, sports and recreation liability, employment practice liability, and subrogation and coverage matters. So with that, can we please welcome our two speakers.
I'll just do a quick test. Everyone can hear me in the back? Okay. I always ask that question not knowing if people don't answer. Have you heard the question? So today we're going to do something a little different. I'm sure you've been to some seminars and some talks where you've heard about the importance of note-taking and KYC points and a lot of typical areas in which you do practice. We are going to touch on those things again, but we're going to do it in a slightly different format, in that we're going to put a mock cross-examination together for you. I'm going to give you some details about a case. We're going to do a cross-examination about some of those key issues in the case. So you'll see when we do the debrief at the end, how these thoughts and these insights that we talk about in professional seminars, how they actually come to fruition in a real-world example. Now, there are a couple of minor notes. For those in the back, that is not me on this slide, although we do share some stellar Arctic blonde hair. And there is a slight change in this evening's program. I will be doing dual duties. I'll be having here as the moderator and talking about some slides. I'm also going to play the role of the financial advisor who's been cross-examined. We just had some scheduling conflicts with our proposed witness, so I'm going to step into that role. So what we're going to do today for our scope of our presentation, I'm going to give you an overview of the examination for discovery process. We'll do a live demonstration, and we'll do a commentary and discussion of the outcome of the case. By show of hands, has anybody had the distinct pleasure of being cross-examined in a lawsuit? Okay. It was fun? That would be the way to describe it? No. Okay. So what an examination for discovery is, it's a mandatory procedure in the litigation process. It's a way to be able to get information from the other side. We all see stories or movies about going to trial and lawyers asking questions and getting yes answers and no answers. Those questions are asked very specifically. We're not going to trial without an understanding of the answers. And where we get those answers is this through examination for a discovery process. In any form of litigation, you're going to have a disclosure of documents. So we defend the advisors. I'm going to get from you all the materials and all your file work. I'm then going to produce that to the other side in the form of an affidavit of documents. I'm going to get their documents from the plaintiff side. So their income loss, whatever they're going to say, I've got all those documents. And then we have an opportunity to examine the other party under oath to get information. Some lawyers use the examination for discovery process as a fact-finding mission or to educate themselves. And while there's a part for that, that's not the real purpose of the examination for discovery. We as lawyers want to go for an examination discovery because we want to know what information is for sure. I mean, we've talked to you, we've met with our so we have your side of the story. We've read the productions, but we need to know the understanding of what's going to happen if we go to trial, if evidence gets reduced to trial, what evidence is the judge going to have to consider. So I don't want to go to trial and ask you or ask the plaintiff a question that I don't know the answer to. So this is a way for me to get some information from the plaintiff. I also want to be able to, at an examination discovery, understand what that plaintiff is going to do at trial. I'm going to ask them a series of questions designed to elicit certain information. So when I ask those same questions at trial, I know what the answer is going to be. And I can use this transcript of this examination discovery to sort of keep the person I'm questioning on track. So if I go to an examination discovery and I ask a question, the plaintiff says yes. And then I go to trial and ask that same question, and I'm asking that question because I want that yes answer, and the plaintiff says no, or I don't remember, I can come back to this transcript that we've got and say, well, wait a minute, I asked you these questions 2 or 3 months ago, do you not remember? So it's a way to make sure that we're taking the witness down where we need them to do. When you're being examined for discovery, it looks like to hear that if you take from this visual representation that the lawyer cross-examining you is going to be standing above you with the light shining on you. That's not the case. It's a much more civilized format, at least it appears to be. We're around a board table. Your lawyer will be sitting next to you, and the opposing lawyer will be on the other side of the boardroom table asking you questions. So when we do the presentation today, Brett will be asking you questions from here and sort of standing over me. That's not how it works in real life. But the way Brett asks the questions and the way it's used is very much how you see it. An examination discovery, you will be asked questions and you will be required to answer all those questions. Some questions are not for you. Conclusion, expert opinions, your lawyer's not going to let you answer those questions. This is a fact finding. So if they talk to you about what's happening with your lawyer, you don't have to answer those. If they want you to give an expert opinion, you don't have to answer those. But any questions about the issues in the issues in the matter, in terms of what advice you gave your client, what you relied on, all those questions, even if you're going to give an answer that maybe not going to help you, may hurt you, have to be answered. It's not a venue to tell your story. You're not going to get up there and be able to say, let me tell you what happened because this is how I recall it. That's not what's going to happen. You're going to be asked a series of questions, and you'll be asked to answer those specific questions. If you veer off topic or give an answer they don't like or is not responsive, the lawyer is going to come back to you and make sure they get the answers they want. This is evidence. Although there's no jury there, although there was no judge there, this is evidence. It can be and will be used against you. If they get admissions from that discovery that is favorable, they're going to make sure that gets before a judge. So it's a formal proceeding. What you say can and will be used against you, so we cannot be flippant. You cannot try and withhold something. So even though there's no judge or jury there, it is a very important part of the trial. And the purpose of that is, like I said, is to get read-ins for trial if we need it, but also to know what we're going to be able to do to put in a trial. Many lawsuits are won and lost at the discovery stage. Now, that's not to say that at the end of the discovery, the lawyer says, okay, well, we're not going to take this to trial anymore, or I capitulate, we're going to pay some money. But the information that we get from discovery informs our analysis of the case. We say, well, when we first got the case, I was told A, B, and C. Now it's apparent that what really happened was D, E, and F, and that's what my client said as the advisor. I'm getting corroborating information from the plaintiff. He gets a much more holistic picture of the case, and we're going to know what happens. So how well the discovery underscore takes that discovery and the admissions that are obtained from discovery are very critical, and you'll see through our examination how Brett elicits some information from me that's very damning. It has been described as a bruising procedure. These lawyers can be aggressive with you. They're not your friends. They may be polite, but they've got an agenda. They're not there to help you. So they can be taking you down the garden path, and you're feeling good about asking questions, and the tone shifts, and all of a sudden you feel like, whoa, I'm in a different movie now. It can be bruising. It's going to be insistent. The lawyer's going to be on you. Now, you're going to have counsel there to protect you to a certain degree. If you're being badged, you're being asked the same question over and over, we as your counsel can interject. But I can't prevent you from asking a relevant question, even though if I know the answer is going to hurt me. If they're badging you and asking you irrelevant questions, I can step in. But I really have a limited role in terms of being able to protect you and shield you from the questions that are going to be asked. So it doesn't work this way. It doesn't work. Hi, please tell me what happened with your client, and then you get to speak for an hour and a half explaining your side of the story. That's not the way it works. These questions are going to be focused. There's going to be interruptions because the lawyer wants to be able to prove certain things and make sure the record reflects their view of the case and how they need to go about moving on. case we're going to talk about today is Murray & Key-based financial. I'm going to play the role of financial advisor. What happened here is my clients sued me for $650,000 on losses from leveraged investments. It's the Smith maneuver. I will not pretend to be as intimately familiar with the Smith maneuver as everyone in this room is. Are we familiar with the concept of the Smith maneuver? I'm definitely going to oversimplify the concept for the purpose of today, but essentially it's a leveraged investment, so we're borrowing money to make some money, but the leverage comes from accessing your home equity, the equity in your home or home equity loan. So it's in a long way, it's a way to kind of do what we have in the United States, make your mortgage, make the interest payments on your mortgage tax deductible, but you have to do it in a convoluted way. But the key for today's exercise is I get equity in my house and I use that equity to borrow money for investments. Now the investments and the idea is that with this investment, the investments are being sold and they're going to generate income that will allow me to both service the debt for the loan as well as have potentially some disposable income. So I'm going to invest. My investments are going to go up, so I'm going to make some money in the long term on investment capital, but I'm also getting regular returns of income so I can downplay so I can pay off the loan myself. So I shouldn't be out of pocket at the end of the day. Now, that's fine when the investments are performing well, but if the mutual funds don't perform well and the value decreases, you can obviously see two problems. One, I've now lost my investment value of the investment. Two, I've now lost the ability to pay the loan, and now I'm in danger of losing my house. So you can see that when you're doing the leveraged investments, it's a high risk strategy. So my clients in this case borrowed a total of $1.7 million in 2007 to invest in these mutual funds. 2009, the value of the funds dropped, and the clients were unable to make interest payments on loans with distributions from funds. Now, I'm getting examined today with respect to one client, and again, realize that I'm pretending to be the financial advisor in this case. This was an issue that affected 25 of my clients. I made the same investment recommendation to 25 of my clients, and luckily, as we'll see, all 25 of my clients, when I recommended these loans and put in the paperwork, had moderate to high risk tolerance and were very good investments. It's amazing how I was able to find 25 people that had exactly what I needed to do to leverage these loans. A complaint was made before the MFDA, and I, as the advisor, we did settle. The settlement was made, and there were some admissions in the settlement. I admitted, as you'll see, that I misrepresented values on the KYC form. You'll see that I made some misrepresentation of the loan documents, and you'll see that I may not have explained the investment properly to my client. So there was a settlement, and we'll talk about the terms of my settlement through the cross-examination. We're going to move to the cross-examination, but I want to take you from this point in terms of what you're going to see what's happened. This is not an unusual circumstance, but what happened here is the case was based on this settlement. My clients wanted to take me to a summary judgment motion. They didn't feel they needed to go through trial because I had an MFDA settlement. There were some admissions in an MFDA settlement. So the purpose of this cross-examination, the focus where I was doing, is to really get the information from the MFDA settlement and have me make those same admissions in the civil case. And so we'll see how that plays out, and then we'll do a debrief of what happens at how the case actually turned out at trial. So. Hope you guys can handle the truth. Brett Stephenson is the lawyer. I am the advisor in the hot seat, and away we go.
He's very nervous.
I'm very nervous. This is my first time here. Is there some water I can have?
I was going to ask if you wanted some water because I think you're going to need it. Good morning, Mr. Gill. I'll start off by asking you a few background questions. I'd appreciate if you could keep your voice up for the record and only respond to the questions that are posed to you. Do you understand that, Mr. Gill?
I do.
First met the plaintiff in 2007.
I did, yes.
They were 61 years old at the time.
Yes.
Neither of them were working full-time, correct?
No, they weren't.
You came to learn that they own two properties.
Yes, two different properties, that's correct.
During this meeting, you brought up something which is called the Smith maneuver. Do you remember that?
Yes,